Welcome to today's Explainer, everyone. We are diving deep into one of the absolute pillars of the Indian Constitution, and that is the evolution of Article 14. Now, I'm going to take this at a nice, steady pace today, pronouncing everything clearly so you can easily take down precise notes. We're going to trace this fascinating journey from the really strict classification tests of the 1950s right up to the dynamic shield against arbitrariness that we rely on today.
Here is our quick roadmap for today. We'll start with an introduction to Article 14, then look at the Doctrine of Reasonable Classification, followed by the Arbitrariness Doctrine, the Golden Triangle, and finally, equality and gender justice.
Let's jump right into Section 1, Introduction to Article 14, the very foundation of equality.
Let's look at the exact text. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Take a second to really absorb that phrasing. Notice how there are actually two distinct guarantees embedded right there in that single sentence.
Contrasting these two concepts side by side actually reveals a whole lot. First, we have equality before law, which has British origins. Now, this is considered a negative concept. It means the state must ensure the complete absence of any special privileges based on birth, religion, or sex. Basically, nobody's above the law. Then we have equal protection of laws, which comes from the American Constitution. This one is a positive concept. It requires the state to ensure equal treatment under equal circumstances. It's an acknowledgement that, society isn't totally uniform, and sometimes true equality actually means treating differently situated people differently.
And that positive concept perfectly tees up Section 2, the Doctrine of Reasonable Classification and the early jurisprudence surrounding it.
So let's look at a foundational case from 1952, State of West Bengal versus Anwar Ali Sarkar. Definitely write that case name down. The facts here are that the West Bengal Special Courts Act allowed the government to direct certain cases to special courts for speedier trials, but they provided absolutely zero guidelines on which cases. So what was held? The Supreme Court invalidated this act. They ruled it conferred arbitrary powers on the government without a clear basis for classification. It left things entirely to the uncontrolled discretion of the state, which is a clear violation of the guarantee of equality.
This case brilliantly illustrates the genesis of our first major legal doctrine. Basically, Article 14 permits reasonable classification, meaning the state can group people or objects for legitimate legislative purposes, but it strictly forbids class legislation. Class legislation is when the state arbitrarily confers privileges on a specific group without any substantial rational basis.
Which brings us to the 1958 case of Ram Krishna Dalmia versus Justice S.R. Tendolkar. This is a massive one. This case firmly established the jurisprudence of equality. The Supreme Court unequivocally held that while Article 14 forbids class legislation, it absolutely permits reasonable classification for legislation. This judgment gave us the definitive, go-to test to determine if a classification is actually constitutional.
And here's that definitive test. It's known as the twin test for reasonable classification. Make sure you get these two steps down. Step 1, Intelligible Differentia. This just means there has to be a clear, smart distinction that separates the people grouped together from the people left out. Step 2, a rational nexus. That means the distinction you made has to have a logical, rational relationship to the actual objective the legislation is trying to achieve.
Moving on to Section 3, we're going to see how this builds into something even more powerful, the Arbitrariness Doctrine, also known as the New Doctrine.
If we trace this shift chronologically, we started in the 1950s with Anwar Ali Sarkar laying down the foundational principles. Then, 1958 gave us the Dalmia case, which established that rigid classification test we just talked about. But then, look at 1974. That is the transformative E.P. Royappa case, where this brand new arbitrariness test was propounded.
Let's break down E.P. Royappa versus State of Tamil Nadu. The facts were that an IAS officer challenged his transfer to a post he felt wasn't legally established, claiming it violated equality rules. Now, interestingly, the petition itself was dismissed by the court because there was a lack of evidence regarding mollified intent. However, what was held legally was absolutely monumental. The court established that equality is a guarantee against state arbitrariness. It fundamentally expanded Article 14 to cover executive discretion.
Justice P.N. Bhagwati captured this idea beautifully in his judgment. I want to read this quote to you. Equality is a dynamic concept with many aspects and dimensions, and it cannot be cribbed, cabined, and confined within traditional and doctrinaire limits. From a positivistic point of view, equality is antithetic to arbitrariness. Meaning, literally, Where arbitrariness begins, equality ends. That brings us nicely to Section 4, the Golden Triangle, where we explore how these interconnected rights work together.
We simply cannot discuss this without looking at the landmark 1978 case Maneka Gandhi v. Union of India. Here, the court was addressing the right to personal liberty and due process after a passport was impounded. What was held here fundamentally altered Indian jurisprudence. A 7-judge bench established that a triumvirate, a golden triangle, exists between Article 14 for equality, Article 19 for freedoms, and Article 21 for the right to life and liberty. They are totally interconnected and must be read together. From Maneka Gandhi, we get the triple test. If any law interferes with personal liberty, it has to satisfy these 3 elements. First, it must prescribe a legal procedure. Second, that procedure has to withstand the tests of fundamental freedoms under Article 19. And third, very importantly, it must be tested with reference to Article 14. This means you can't just have a procedure on paper. That procedure must be just, fair, and absolutely not arbitrary, fanciful, or oppressive.
Let's open our final section, Section 5, Equality and Gender Justice, to look at some modern applications.
Let's look at the 1978 case of Air India versus Nargish Mirza. The facts here are pretty striking. Female flight attendants working for the state-owned airline were being forced to retire under 3 conditions: reaching 35 years of age, upon getting married, or upon their first pregnancy. Male attendants, however, faced no such rules. So what was held? Well, the Supreme Court applied the arbitrariness test and struck those rules down. They held that these requirements were official arbitrariness and hostile discrimination, which directly violated Article 14.
Building on that exact momentum is the 1997 case Visakha v. State of Rajasthan. This judgment sought to enforce the fundamental rights of working women. The court held that sexual harassment at the workplace is a fundamental violation of the right to gender equality, which is codified right under Article 14. Even without an express statute existing at the time, the court found this protection implicitly woven into the fundamental rights guarantee.
Fast forward a bit to the 2017 case of Shayara Bano versus Union of India. Here, the petitioner challenged the constitutionality of practices like instant triple talaq or talaq-e-bidat. By a 3-2 majority, the Supreme Court declared the practice unconstitutional. What was held by the majority was that the practice was manifestly arbitrary, meaning it clearly and obviously failed the test of Article 14.
Now, it's really important for your notes that we clarify the differing perspectives of this 5-judge bench. The majority applied the doctrine of manifest arbitrariness. They observed that gender equity is totally entwined in Article 14, and conferring social status based on patriarchal values is simply incompatible with the Constitution. The minority opinion, however, had a different focus. They emphasized the separation of powers, stating that reforms in uncodified personal laws belong strictly in the legislative domain, and they advocated for judicial restraint. It's a fascinating example of how constitutional law can be interpreted from different angles.
It's also vital to note that the rule of law under Article 14 isn't some absolute barrier to special treatment when the end goal is actual justice. Creating special provisions to improve women's participation, like affirmative action or reservations in employment, is a specific facet of Article 15, Clause 3. The courts have held time and again that this works alongside and completely in harmony with the reasonable classification permitted by Article 14, recognizing our real-world socioeconomic realities.
To wrap up our deep dive today, Article 14 is truly a living guarantee. We've seen how it brilliantly evolved from a rigid, formulaic test of reasonable classification into this dynamic, all-encompassing shield against state arbitrariness. It is, without a doubt, the very heartbeat of fairness in the Indian legal system.
I want to leave you with a final, provocative thought. As our society continues to evolve, think about new technologies, unprecedented government policies, shifting social norms. What new forms of state action will the arbitrariness doctrine be called upon to test next? Keep studying, keep questioning, and keep relying on the fundamental principles of the Constitution. Thanks for joining me on this explainer.